Judge President and Commissioner Nyokesi drew me to what I'm going to ask you on. You were asked a question in relation to the quality of judges and the judgments and the criticisms. And you repeatedly said that there are no criticism that you are aware of, and correctly so, because we have not been furnished with any. And Commissioner Nyokesi also asked about the quality, and you also said you yourself are not aware of the challenges in your judgments. And then that drew me to the judgments of yours that I know I've read before. The first one is the one where you dealt with Matrimonial Property Act, and you dealt with issues of forfeiture and all those kind of things. But for the purpose of time, I want to go to another one that you wrote. This one you wrote, and that judgment was riddled with difficulties, right? Which I'm not really sure why the independent bodies were not able to pick up on those. But the one that I want to debate with you on is the one that you wrote in insolvency law. The body corporate of Heiselhurst versus Ramachia. It was delivered on the 27th of October 2017. I'm not sure if you remember that judgment. It dealt with, from what I can gather when I read the facts, it was compulsory sequestration. But when I read the judgment, it seems like you are confusing compulsory sequestration with voluntary surrender. And I'm going to point out something and I want your comment on it. The difficulty that I have with this judgment is, and I'm not sure, it's not part of the PEG, unfortunately. I don't think it's part of the PEG.
Of the bundle?
Yes. In paragraph 9 of that judgment, but do you remember that judgment?
It's
because I want to be fair on you, but the thing is, I'm asking this based on the criticism that you raised.
If it's a 27 judgment, it's
2017.
Yeah, 2017. It's some time ago. I've had a couple of insolvency matters which I heard. So no, I don't recall.
But can I just point out?
Yes, you can.
The issues with this judgment in response to your response in relation to the quality of your judgment?
Yes, please.
In paragraph 9 of that, in paragraph 9 of this judgment, what you first do, you speak about the acts of insolvency, and you list about 5 of them. And when you start speaking about acts of insolvency, you give an impression that you are dealing with compulsory sequestration. In other words, what you are dealing with here is compulsory sequestration. And once you have outlined these, in the following paragraphs, you don't even deal with any of these acts of insolvency and what or which one of them is actually applicable in this case. And there is no reasoning in relation to the requirements of compulsory sequestration and as to why the person who is being sequestrated in this particular matter meets those requirements. And that is the first flaw that I found in this judgment. But apart from that, you confuse issues. In paragraph 21 of that judgment, you say something that is quite surprising. You speak about somebody making a notice to surrender their estate. And if you start saying somebody surrendering their estate, you moved away completely from compulsory sequestration. Yeah. You are now dealing with voluntary surrender. And that is the second issue that I have with this judgment. That shows, one, confusion in relation to the area of law. But secondly, lack of attention in relation to the research that is needed to actually get into the reasoning and the order that you're going to give. But the third fundamental challenge with this judgment is the language that is used. In paragraph, you can just bear with me just for a second. In paragraph, I think 20 of the judgment, the language, the sentence construction that is used there, and when you read the entire judgment, and I mean it's unfair because you don't have that judgment, so you can see. But I just want to say that this judgment and the judgment that I referred to, it has similar sort of things that come out of them, where you rely on the law, not the law in terms of cases, but the law in terms of the statute itself, but your interpretation of the statute and your reasoning in relation to the statute leaves much to be desired. So I'm not sure whether it's accurate to say that the quality of your work generally, it is satisfactory. I think there are points of weaknesses, And it's quite disappointing that some of the bodies have not highlighted it, and which raises a concern that perhaps maybe criticism seems to be restricted to certain people and not other people. And that for me is a concern. I'm not sure. What is your response to that?
Firstly, Commissioner...
No, DCJ.
Commissioner Malema?
I think in all fairness, that question is not in keeping with what we have adopted. Because it's not only the law bodies that have got a right to raise issues with the candidate before he sits here. We all do. If we look at the law bodies report and the issues we have, which the law bodies have not raised, we all have a right to raise those issues and send them to the candidate. And that hasn't been done. And it's not me, it is through the admission of the commissioner that hasn't been done. And it's unfair to the candidate and to all of us, because even in the deliberations, that point cannot be referred to, since it has not been canvassed.
Thank you, Commissioner Malema.
Before that, I take a point, but the thing is, I'm raising an issue based on a judgment which is a public document, which, of course, all of us will have access to. And we did that even yesterday, where somebody said the Supreme Court of Appeal confirmed me, and we all went to try to see whether indeed the Supreme Court of Appeal has actually done that. So the question that I'm raising is in relation to the judgment that the candidate actually authored. So it's not about the bodies or any other person criticizing. So it's my criticism to the candidate. So it's not really about anyone else. It's my criticism as the commissioner to the candidate.
Thank you. I hear you, Prof. But look, the judgment you say was written in 2017, and he has written dozens of other judgments since. So it may actually, I'm trying to put myself in his position, and I'm thinking, out of all the judgments I've written, if I were asked on a judgment I'd written 5-6 years ago,
I accept that.
It might be difficult. But the Advocate Olan Muta looks ready to answer. I don't know what he was going to say. Let's hear from him. If you feel that the question is unfair, you will say.
Before that, DCJ, let me just say this. I understand that. I said the question was based on the assumption, or the saying that there's never been a critique in my judgment. Then he went further and said, I am not aware of any challenges in my judgment. So I was asking on basis of the second leg, I am not aware. So I was raising that on that aspect.
And I just ask for clarity if this judgment was appealed against?
No, it wasn't.
It wasn't. All right.
If I may, Deputy Chief Justice, respond to that, and I would like to thank Commissioner Malema for that. Yeah, it is an ambush question, and I cannot respond to that because I don't have it before me. I'd never said that I never made a mistake in any judgments. I said, in overall, I am not aware of criticism. And if this is a valid criticism, I would have expected, and in all fairness to all candidates, not only for me, but all the candidates who come here, is that you have in advance that criticism circulated you so that you can be prepared. That is as far as I would go. I cannot comment on that. But a last thing is, if it was 2017, yes, I would agree in general that the quality of my writing of 2015, 2016, 17 is not as good as it is today because there is an improvement.
Commissioner Malema?
No, thank you very much. SC, I never heard you saying that your judgments, both in language and writing, are A+.
No, I didn't say A+. I said I don't have serious comments, criticism.
Yes, I heard you saying from the law bodies, and that question came from the JP.
Yes.
There hasn't been serious criticisms
Yes.
from that end. And that doesn't mean there won't be typos and all of that, because you just told us that English is not your first language.
That's correct.
Thank you.
Thank you, Commissioner Malema. Any further questions, colleagues? All right. Well,